Welcome to Shenkman Education. My name is Marty Shenkman. The topic of this video clip is what happens when you die, somebody dies, and they had a properly drafted signed will. When you die with a will, the will is one of the major documents that governs what happens with your assets when you die. It also appoints a person, which could be called an executor or a personal representative, to administer or manage your estate. It also designates, if you have minor children, guardians. Hopefully it's done all that. If somebody you love or a family member, friend dies and they had a will, and by the way, similar concepts with the revocable trust, the first thing to do is to get information together. You got to have information to properly understand what the document is going to have by way of an impact. The information you need is really three things. You need first a balance sheet. You need to know the assets, and most important, the title or ownership of assets, and we're going to come back to that. Second, you need a family tree listing all the family members and maybe other important people. You need to know the relationships because most documents provide for how assets go, and many wills and revocable trusts have language like the heirs at law. Well, what's heirs at law? You need to first know the family data. There's also a concept under state law of a spousal right of election, so that if there's a spouse, they have certain minimum rights of assets they may be able to demand from an estate. You need to know that because it may very well be that what's specified in the will gives less than what's required to a spouse. And it gets more complicated, which is not the magic bullets people are often looking for, but reality. Was there a prenup? Was there a postnup? Does that affect the spousal right of election? Was there a waiver of the spousal right of election? So it really kind of is part of the family information. You got to get relevant legal documents that pertain to family. The third and most obvious thing is you need a copy of the will. I'm going to tell you how I address this because it may be practical and helpful for you. And everyone may find a different way to do it. You could print a physical copy of the will and use a highlighter and different colored pens and mark out the different provisions. What I do is you end up getting a PDF version of the signed will. I convert it to Word, and then I can annotate it using highlights and colors to do it. And what I seek to do is highlight the relevant provisions to how we administer the estate and who gets what. When you're drafting a will, you may be thinking about different things, and there's a lot of boilerplate and other things that need to be addressed. If you're the personal representative, the executor, or just a concerned family member or beneficiary, and you want to know what's going on, you want to annotate the will to see how that all affects you. Now you have your roadmap. You have what the will provides, annotated, maybe comments. Second, you have the assets to see how they flow under the document, and I'm going to come back to that assets. And then you have the family members because that's also necessary. So with those three steps, those three inputs, you can now evaluate and create what I'll call a roadmap for how to address administration of the estate. And again, if it's a revocable trust, very similar. I mentioned a couple times assets, and there's other video clips that talk about this, but it's really important. Example, if the deceased owned a bank account joint with child A, that bank account is going to child A on the decedent's death. If the decedent had a life insurance policy and it mentioned Aunt Edna as the beneficiary, or specified that, then Aunt Edna is getting the insurance. It doesn't matter what the will or revocable trust have to say. So you need to understand the title and legal structure of assets. Now, and this is kind of why you also probably at least want to get an attorney that specializes in this involved for purposes of at least helping create this roadmap that we're kind of describing. Sometimes the will or the title to the assets sends assets or directs assets to go where you don't want them. And if that's the case, what you might do is use disclaimers or other mechanisms to try to get the assets back to where they're desired to be. So it can get complicated. And also, and this is really important, with a will, without a will, with a rev trust, without a rev trust, you got to do the planning. You should do the planning no matter how rich or poor. Everybody has family and issues and things and desires of what they want done. But it's very, very hard to predict the emotional reactions that many loved ones, family, or others, doesn't have to only be family, may have to somebody's passing. And that can be another sort of uncertain dynamic that affects this whole process. So the bottom line is, if somebody dies with a will, you need to go through the document. You need to understand its impact on how assets will pass, how the estate is administered. You have to determine who's named as executor. If that person's not alive, not well, or doesn't want to do it, who's a successor, because then that person's going to be there. With a will, you have to go to court, surrogate court, probate court, and get the document admitted to court. You get what's called letters testamentary to administer the estate. It's just an official document rooted in paper, not electronic documents, designating that person as having the authority to act. By the way, when you can get letters testamentary, or they may be called by a different name in your jurisdiction, get a couple dozen of them. They're usually not that expensive, but the process of going back can be tedious, and if you're hiring a lawyer, very costly to just get more letters testamentary later. So get a whole bunch of them so you have more than you need, because every bank, every brokerage account may need one. You're going to need one for filing a tax return if you do. And by the way, tax return. Even if your estate is modest, you may want to file an estate tax return to secure the exemption amount that the first decedent had. And that's really important, and a lot of people miss that. Even if your estate is small, what if the surviving spouse remarries, inherits a lot of money, wins the lottery? Now you could have an estate tax, and no one knows what the estate tax rules will be in the future. For a pretty modest cost, you can get a simplified estate tax return filed just to secure the exemption from the first spouse to die. And just using that as an example, there's so many nuances and other things, from government benefits, income tax filings, the status that you use on your income tax returns. It's really hard for a non-professional to grasp all the different things that we've mentioned. So you at least get a professional involved to identify the different things for you. You may need an accountant as well as a lawyer, but at least get a consult so you identify what you have to do. Once you have all the information about the topics that we've talked about, and there's a lot that we can't cover in this quick video clip, then you may be able to handle a lot of the administration on your own and save professional fees. But get the knowledge and information first so you know what to do. And hopefully these discussions have given you some guidance on how to start. And by the way, if you gather all the information, all the assets, all the title documents, copies of bank statements, copies of deeds, and all that before you sit down with a professional, you'll greatly reduce the cost involved of what the professional is going to have to do to help you. Thank you for joining me. Please keep in mind all the information on the video clip is for educational purposes only. Don't take any action without appropriate professional advice. Good luck, and thank you.